Okay. So tonight we're going to talk about deeds, title, and closing. When I talk about deeds, title, and closing, again, what kind of comes to mind? How many of you have had a chance to actually look ahead a little bit and see what we're talking about tonight?
It's kind of what we talked about last night with Vivian.
Okay.
Titles and deeds.
And Vivian's a lawyer. It's interesting to hear her, but she's a realtor as well. So when she's teaching the P&P class, she's bringing you the realtor look at it, but also because she's a lawyer and because of her job and the kind of stuff she deals with, she gets into intricacies of things, very much so. So what are the kind of things that takeaways from last night quickly?
It was like general warranty deeds and like limited warranty deeds and then like what else was it? What was the last
Quick
one?
claim.
Oh, yeah,
Quick claim deed?
Yeah.
Okay. So obviously, we're going to talk about the warranties. And the warranty is something that's presented to you at the closing, but you negotiate the terms of the warranty before you get to closing, when you make your offer, your contract. And only certain people can give certain warranties. So that's what we're going to learn about. And obviously, the general warranty is the most favored. And it's the most used in residential, is a general warranty deed.
And just little stuff too, like intestate.
Okay, and dying intestate, what happens? Okay. All right. Okay, so for those of you that just walked in, like I said, next week we won't have class because I'm having my mother's funeral, but in 2 weeks we'll come back. We'll go through 12 and 13, and then we'll have the midterm, that second half of that class. Okay, so deeds, title, and closing. Kinds of things we're going to learn tonight. Again, it is going to be a little bit of a review. This is where it ties in a little bit to what we did. We're going to talk about terms, title, and how ownership is verified. And I worked for a title company for a little while, and we'll talk about some of that. We're going to explain the promises made when a deed is delivered. We're going to talk about the differences among the types of recording statutes and what's a race to record statute versus other statutes. We're going to understand the concept of marketable title. We're going to explain the various ways to provide title assurances. And then we're going to talk about the actions that occur in the title and escrow closings and how they give the final document to you and everything. So deed. The basic piece of the deed is the title is the ownership of land. And the deed is the written instrument used to convey or transfer the property. So when we sell a car, we actually use something called a title. It's a little piece of paper, it's a title. But when we sell real estate, we actually have to go through a contract because it has to be in writing for statute of frauds, but then we use this thing called a deed to actually make the transfer. So deed will determine the exact property, the estate or the interest being conveyed, and then its conveyance causes ownership of the estate to transfer from one person, the grantor, to another person, the grantee. Two pieces you need to take about that. Grantor, grantee. Two things that you'll need to know those terms for your real estate exam. Who is the grantor? Who's the grantee? The grantor is the giver, and the grantee is the person that gets. The requirements for a deed. Oh, guess what? This kind of looks like a contract. Kind of. All states set minimum requirements that must be met before a deed has legal significance. So the requirements generally include the following. It has to be in writing and signed by the grantor. So the person that's giving. Now the other thing is the grantor, if it's a married couple, it has to be signed by both because of dower rights. The grantor and grantee must be clearly identified. So who's selling and who's getting. The grantor must have legal capacity. So it's that whole test. Is the grantor somebody that has capacity of sound mind and everything? Are they ready to be able to give? Are they doing this of their own free will, basically? The property must be adequately described. This is where we're going to have usually a legal description comes with that deed. And it's not just simply a street address or a post office box or something like that, or a condo unit number. It's a full legal description. The deed must express the intent immediately to convey the property interest to the grantee, so there's language that says we're conveying it. The deed has to specify the type of interest and the rights given. And the deed has to be acknowledged. So it's going to have some kind of a notary or an attorney that's acknowledged the deed. So it's formal. And the deed has to be delivered by the grantor and accepted by the grantee. So delivered by the grantor, okay, when we go to roundtable closing, it's given right then and there. But typically it's given, and then it's given back to the clerk so they can go record it. Then they eventually will mail it back to the person. But if you're doing an escrow closing, the deed is eventually delivered with the closing paperwork to the people. But it has to be delivered. That's a real piece. You know, you'll read stories about, oh, the attorney did all this and did that, and then they shoved the deed in their drawer and they never delivered it. Well, if they never delivered it, it never completed the sale. So it has to be delivered. Title assurance means that a person is recognized as having evidence of title and real property. So do they have title? We've done a title search to prove that they indeed have title. They are the rightful owners of the property. They have the ability then to transfer. Part of that bundle of rights. We have the right to own and buy and sell. This is the title is recognizing that. The 4 methods of assuring the buyer of title. We have six covenants from a general or special warranty deed. We have a system of recording land titles. We have title registration called the Torrens system. And then we have title insurance. The title registration and something called the Torrens system. We also have properties that are registered land, and you'll see a registered land or a Torrens certificate. It's this great big certificate that they pull out every time that registered land transfers, and you can see everything in writing on that piece, on that one document that gets filed at the courthouse. It never leaves the courthouse. And title insurance. When you are using a mortgage, they're going to require you to get title insurance. When you're buying property for cash, you're not required to get title insurance. But we will tell you to tell your customers, anybody buying with cash should always get title insurance. After the closing, you can get it so many days after the closing, apply for it, get it done. Because that title insurance is that review of title, that's looking back over the title to make sure there's no clouds. Clouds can be liens. It can be people that should have inherited the property through some kind of transfer. It can be anybody else that has claim to title. When I worked at the title company, they used to tell me the story about making the phone call to call somebody and say, we forgot to get this from you. Talk to the wife, it answers the phone, and she's like, what do you mean you forgot to get something from me? And she found out then that her husband had gone to a closing with a girlfriend or somebody else that portrayed that person, and realized then that, oh gosh, you know, they're trying to sell the house out from under me. But it wasn't a true closing. So another thing that we do at closings today is we actually ask for a driver's license, and they'll make a copy of your driver's license. When I started doing title work or closings in the early 90s, I just go in, they knew me, hey Joyce, how you doing? Come in, sign the paperwork. They never asked for my driver's license. But today, even though they would know me, they would still ask for my driver's license. They still make a copy of it. Driver's license can be faked. You can get, you know, copies of driver's licenses and stuff like that. But the title company, it's not their job to verify that you really are who you are. They're not doing the 1,000-question background check. If you bring a driver's license, they're assuming the person that has a driver's license is who they say they are. And that's all they can do. It's not their job to go back and do more. But through title records, they'll do some things to verify some information. Types of deeds. The most commonly used type of deed includes what we call the general warranty deed. This is the deed that we use most often in residential. It provides 6 covenants or warranties to the grantee, their present covenants and their future covenants. But it also says that, hey, I'll go back in history since this property was created through this general warranty deed, and I'm going to tell you it's a good title. That's kind of what the general warranty deed is doing. Everything I can help you out to assure it's good title, that's what general warranty deed does. This is part of the whole thing in Cincinnati in our market until the early 90s. We didn't believe that the sellers were giving us good title. We didn't believe what a general warranty deed really was. And in our market, the buyers always bought title insurance. But now, today, the sellers provide title insurance, at least the first $300 or $400 of title insurance to give the owner's title policy. Not the mortgage title policy, the owner's title policy. So again, it's the general warranty deed says we're going to go back in history and back in time. and we're going to tell you we got a good title. The special warranty deed, the grantor warrants that he or she has not caused any defects in the title during his or her period of ownership of the property. So while I've owned the property, I haven't done anything. I mean, I might have recorded easements, I might have done some other things, but they're a record. And so while I've owned this, anything that's happened while I've owned it, we know about. It's being disclosed. We'll tell you about it. We'll try to remember it. The special warranty deed is kind of also when companies, corporations sell real estate. Corporations cannot give a general warranty deed. It's just not allowed. Commercial entity can't give a general warranty deed. But they do give special warranty or limited warranty deeds. Again, that's basically saying while the company or corporation has owned the property, they'll represent the title during the time they've owned property. So remember that too when you take your exams. Companies, commercial entities cannot give general warranty deeds. And very often, years ago when I'd see a lot of work come through, when I was a real estate manager at Ohio Casualty, it would say a general warranty deed, and that was one of the first things I would strike out. We'll give a limited warranty deed as a company. Because they're not a person. That's why they can't give it. A grant deed implies two covenants. The grantor has not previously conveyed the same estate to anyone other than the grantee. The property is free of encumbrances placed on the property or permitted by the grantor. So that's all it's doing. The grant deed is just real simple. I've never granted it to anybody else, and while I'm giving it to you, I haven't done anything else to encumber the title. The deed of bargain and sale conveys real property, implies that the grantor has a claim of ownership in the property, but the grantor makes no other covenants to the grantee. So I have ownership, but I'm not giving you any warranties at all. I'm just telling you I had ownership. Period. Nothing more. A quitclaim deed is a deed in which the grantor conveys what interest, if any, the grantor has in a specific piece of property. The most oftentimes we see a quitclaim deed used is during divorce. One spouse is quitclaiming their title to the other. Again, this is done because of their divorce proceedings, what they've agreed to do. When I first started working as a real estate broker, the guy that was in the office with me said, "Joyce, I need you to notarize this deed for me." He was doing a quitclaim deed with his roommate. They bought a house together. He was willing to give title to his roommate. He didn't want money or anything like that. He was just ready to move on because he was getting married. Him and his wife were going to buy a house. He was just ready to give up ownership. So he was doing a quitclaim deed just to say, I give up all of my claims. Give it to my roommate. Judicial deeds and trustee deeds is issued as a result of a court order. Trustee deed is a deed issued by the trustee in a court-supervised foreclosure or non-judicial foreclosure. Now, because I used to work in the trust department and I was a trustee, I still have a hard time getting my head around this trustee deed because we gave basically trustee deeds too when we were selling something from as the executor of the estate or as the trustee of the property, but really it was a special or limited warranty deed. It wasn't, quote, a trustee's deed is what we were given. Because as the trustee, we couldn't go back and make title claims. We wouldn't go back and insure title. We weren't doing general warranty deeds. We were just saying, well, we've owned it. And if we're the executor, we really never owned it except for a few days while we were the executor to try to get title passed from one to the other. So it's a very limited period of time in what we were able to warrant. Judicial deeds, trustee deeds, again, used in foreclosures or non-judicial type foreclosures. Recording. We want to do this to protect title by preventing fraud. So every major county in Ohio, we're called counties, has a place, a courthouse, where they record all of their real estate documents. Every major municipality will have something like that. In Ohio, it's our county seats. So Hamilton County and Cincinnati, in Hamilton and Butler County is the county seat. You'll go to whatever the county seat is, to their county administration building, and there's a recording office where they keep all these records. And we want to record because that lets the title company and everybody come in and see what's done of record. By recording it, we're going to the open public to say, here it is. You and I know a little bit, but the average person doesn't know how to go in a courthouse and research the records. You're trained to do that. But we're still, by the fact that we've recorded it, we've given the world public notice. It's like putting it on a little bulletin board to tell everybody, we've done this, here it is. It establishes a priority rights between and among conflicting deeds on a particular property. Again, that might be who recorded first or who takes priority. What can be recorded? Any instruments that affect title to land. So we see easements recorded. We'll see leases recorded. I have commercial leases that get recorded. When a tenant has a long-term lease and they're putting a lot of money into the property, they don't own the property, but they've got a lease on the property, so they've got this leasehold estate for a limited period of time, but they're trying to tell the banks and anybody else that's interested in that property, they have a leasehold interest for a period of time, especially when they put money into the property. So they may record what we call a memorandum of lease. It's not the 60-page lease. It's a 3-page document that says we have a lease for this period of time. It doesn't go into all of the rent payments and all that. It's just simply a document that says we have a lease for this period of time at this property. So we're notifying the public to tell them what we've done with a recording of memorandum of lease. Where the documents are recorded, again, each county, parish, or township maintains an office for the recording of instruments. And how are the records maintained? They're maintained through a grantor-grantee index and a tracts index system. Years ago, we would go pull a little index card, and we'd use the index card to try to go find where we had to go find the book plat, parcel number, where things are recorded. Today, most of it's online. There's still some old records that are not online, but a lot of our counties and places that are recording have moved their documents to online, so they're available. Sometimes you can go online and find the information from home. Other times you have to go online, but only at the county recorder's office. They don't let just anybody come in. You have to be at their office to be able to go online. So different places are trying to keep their own security to do this. Recording statutes. We have a race statute, which is the first party to record takes title to property, even if the first to record obtain their interest later in time. So in Ohio, when you go to a closing, if you go to a closing in the morning, they're taking your mortgage and your paperwork to the courthouse that afternoon. If you go that afternoon, they're going to make their visit the first thing in the morning, because Ohio is a race statute state. The first person that records has priority. When the Kenwood building on the hill was being built, the mortgage company didn't record their mortgage for a month. And while that month was going along, the contractors recorded liens. So they stepped in front of the mortgage. And that's another reason mortgage companies want to record right away. They don't want lien holders to be able to step in front of them. There's only one lien that should be able to step in front of a mortgage, and that's the lien for taxes. No matter what happens, the taxes will be able to step in front of a mortgage. But other than that, the mortgage wants to be recorded first so that they're always paid first, then lien holders get paid behind them. The notice statute is the last bona fide purchaser takes title to the property, is the person that's entitled to have it. And the race notice statute, again, first BF to record keeps title to the property. So Ohio is the race notice statute. Marketable title. It's a title that's free from any encumbrances or liens, except those that the buyer is aware of and has agreed to accept in the sales contract, and free from reasonable doubt that the seller owns title. Okay. Everybody has utility easements. Easements in gross that are the utility easements that run right across the front of your property. When we go to buy and sell real estate, we very much take for granted that that's out there. We usually don't even talk about it. Go drive up to a property. It can be underground wiring or it can be overhead wiring. But somehow or another, you got to get electric to come into your house, or gas, or utilities to come in your house. So there's easements to do that. We actually, when we own property, we really own to the middle of the street. But the state or the county or whoever has rights to the roadway. And then if there's a sidewalk that runs through your property, it's yours. You own it. You have to maintain it. You're responsible for all liability on it. But you allow anybody to pass on it. You can't put barricades up in front of your sidewalk. You're not supposed to be able to park your car, to block your sidewalk. It's always supposed to be free for people to walk on the sidewalk. So you're giving everybody the right to walk across your property on the front. Not to cut through your property, through your backyard and stuff like that, but you're giving them the right to walk across the front.
What about the people that, like, if the street is too thin, they'll kind of like park their car onto, you know what I mean?
Under the curb edge.
Yeah, well, some are like actually coming on the sidewalk because they just don't want to.
Yeah, but that's not supposed to be.
So you can get like.
You can get ticketed for that. Yeah. And in Fairfax, where I live, if you park the wrong way on the street, you can get ticketed. Now, you go next door into Marymount, people park the wrong way on the street all the time. They pull up in front of their house the wrong way and park and leave it there. They never get a ticket. So I pulled in one day to try to just deliver something really quick. It was a heavy package. I wanted to pull at the wrong side of the road and get it out of my vehicle. Cop pulled up next to me and said, "What do you think, we're in Marymount?" I'm like, "No, I just wanted to make a delivery, just don't hassle me." But again, depends upon the community and how their norms are, what they're practicing. We also have a lot of tight neighborhoods where you have the alley street in the back that comes to the garages. And there's regulations on how you can park on those alley streets and use those alley streets as well. But those alley streets, again, they're part of private property. You're just giving people easements to come through your backyard when you have those alley type streets. So, marketable title, again, free from any encumbrances. But we have encumbrances just because we do it. Do we know about them? No. Most people that aren't in real estate don't realize what an encumbrance is. And they've lived in a house a long time, and they may forget, oh, we did a deal with Duke Energy, we got $10,000, and we gave them a piece of our land. They may remember that. That was an event. But if it's just a quick, simple easement to get something, they didn't get a lot of money, they may forget that they ever did it. But that's where, again, those things are recorded, and the title company will find all those encumbrances. The title, it compels seller to correct any defects in title or purchase title insurance to ensure title of the property before the close of escrow. So again, by giving this general warranty deed, we're telling our buyers that we're going to make our title good. That's part of the whole general warranty thing. We're going to make our title good, and we're going to do everything. If the title company finds anything, we're going to do our best attempt to clean up the title. That's what a general warranty deed is doing. Each state has enacted a Marketable Record Title Act. So we have something like that to be able to transfer titles. We need to know what's marketable title. What's the state define as marketable title? It varies from state to state. It's similar, but it can vary a little from state to state. Proof of marketable title. There are three common methods of providing proof. We can get abstract of title. That's basically a chain of title, title abstract, and title opinion. And if you buy title insurance, that's the first thing they're doing. They're sending a clerk down there to abstract titles. And what they're doing is just pulling all the title information from the records to see that it's clean title or if there's clouds on title. They want to see that chain is complete all the way through. Clouds of title means the chain's broken and they find something else somewhere. I had a property that was in West Virginia. It was 2,200 acres. It had been coal mined, deep mined, all kinds of stuff. The property owners were doing all kinds of mining leases in 30s and 40s, try to make money off their property. We went back to investigate it, and we found that the way that the titles, the leases basically were written, they overlapped. It didn't impact the people today that are owning the real estate and collecting the money from all the mining companies. But what it impacts is how they can sell the property, because it would cost thousands of dollars to clean up all those title problems. But it doesn't impact, again, if they're not selling the property, they can just keep sitting back and collecting all the income from all the mining companies. Not a problem. But if they try to sell, that's where the hiccup comes in when we try to transfer title. Liens on property. Liens can sit there forever. By the way, your first lien is your mortgage and taxes, things that you have to do. But the mechanics liens, things like that, they can sit there forever. It's when somebody goes to actually transfer title or refinance. That's when they'll pull all this stuff up. That's how contractors have the ability to strong arm us to get us to pay for their work. Because they can say, wait a minute, I just did all this work on your property, I'm going to file a lien. And if you ever want to go refinance it or sell it, you're going to have to settle with me. So that's, again, that's their only real strong arm method to get you to actually pay their bill. We have title insurance, again, that gets issued. And then this Torrens system is title registration. So those are marketable titles.
Is there a minimum amount that needs to be?
I don't know if $1,000 would be a minimal amount. It's whoever's time and effort that it takes to file the lien and go through the paperwork and do it all.
Gotcha.
I'm going to give you an assignment for 2 weeks from now. See what you can find out if there is some kind of minimum required in Hamilton County for filing liens. You'll just you'll find out, go to the website, county auditor's website, or even just the general Google and filing liens in Ohio. What's the minimum amount? You should be able to find the answer pretty quick. He's probably doing it right now. Are you doing it now? What are you finding?
Let's see.
I'm curious because you asked the question. I want to know.
Well, I sold the house, we were selling our house in Cleveland, and we had a small addition put on a couple of years ahead of time. It was only like $16,000 addition to the house, but the everything was in the contract. All the electrical, plumbing, everything was in there. And then when we went to sell, the electrician put a lien on the house for $1,200 worth of work he did. He had already retired, moved to Florida. The business that we did, the business with, he closed up. We had no choice. We're going to do try and sue this guy for $1,200 to get my money back.
So you
We
paid
just
somebody
paid it and sold the
$1,200,
house.
but who did you pay the $1,200 to?
The contractor.
GC.
He never paid the electrician.
Oh, okay.
So,
But
How's that fair?
so how did
It's
you
not.
you paid the GC again, or you had to go find the electrician to pay? Because somebody had to sign off on the lien waiver. There's a lien waiver that got signed off on for the title company to finally say you're good.
But all we did was sign a check for $1,200. Mailed it down to
It seems
Florida.
like the
Okay.
electrician should have took it off with the GC.
They should have, but they don't always. And that's where we don't always know those things. Okay, I'm getting ready to do work at the building now. We're going to have $30,000 worth of air conditioning equipment put on the building. But we're going to pay the tenant back right away after it's done. He's banking it and getting it done. But he won't be done with his work for 120 days. And we'll pay him the rest of the contract then. But before I can actually pay him for those HVAC units, I want a lien waiver from the HVAC contractor. He signed a lien waiver before he ever got paid because of our process, because I'm going to get a lien waiver before I do everything to make sure things are going on. They haven't given up their rights. They can still perfect it if they need to. But because it's commercial property, because we have all these rules, we're real thorough about making all that, making sure our paperwork's done. Most residential people don't have a clue that there's something called a lien waiver, that you have contractors sign that they've been paid, that they can't file against you. Residential people don't have a clue.
And that's a standard form you can just download?
It is. There are standard forms, but again, most people don't understand the process, so they can be taken advantage of. And yes, people can do all kinds of things and file paperwork later. Like you said, you had no idea that General didn't pay the sub. You know, I've got some situations now just from word of mouth. I know that some of my subs on my snow removal weren't paid last year, but they're not filing lien waivers. But they could, and if they did, I'd go back and sue the contractor.
So you would have the contractor sign the residential lien waiver as you are paying them?
In return for this check to get paid, I want you to sign a lien waiver. And I keep that documentation with all of my paperwork, and it's filed. It's the same kind of thing after you sold a house and your mortgage gets paid off. The best thing you can do is the real estate person selling the house, give the satisfaction of mortgage. It gets recorded. Make sure you get that for your client and get it to them, and have them keep it with their important papers. It's definitely a piece that should be kept in a lockbox or strong box, because you never know, 15, 20 years from now, somebody might come back and say, that bank doesn't exist anymore, and we can't figure out how the mortgage was ever satisfied. If you've got the paperwork to give it to them, it's a relief to have it. And again, that's part of this clean title, to know things are being done. Closing or settlement. At the closing, the buyer receives a deed, and the seller receives payment for the property. Pretty simple. We exchange paperwork for money. For the preparation for the closing, closing statement states the distribution of monies that will occur at the time of closing. During the pre-closing phase of the transaction, several activities occur, including the following. And I just wanted to look. I think in our textbook, I seem to remember this. Yeah. In our textbook on page 291 is an actual closing statement. So you can see how the closing statement flows and works to have a record of one. Did you figure out, did you find answer liens?
So there's like, technically there's not a minimum.
No minimum.
There's no minimum. You can pay like $1 if you wanted to.
Yeah. Again, but is it worth your time to go down to the courthouse to file the paperwork and get it all done?
They like, if you, the basic recording fees is like $28 for the first 2 pages, and then each additional page is $8.
Okay. So it's got to be worth whoever's time to go pay to park, to go to the courthouse, to take a couple hours to go do all that.
If you want to do it out of spite.
Oh, you can do anything out of spite.
I mean, that's worth
Absolutely.
it.
Absolutely. Out of spite, you can do it. Yes, it sure is. Yeah. Interesting. Okay, so during the pre-closing phase of the transaction, several activities occur, including the following. We have an inspection of the property, we have the appraisal of the property, we secure the title commitment, and we secure commitment for the homeowner's insurance. So when you go to a closing, you're going to bring evidence as the new buyer that you have homeowner's insurance. And the mortgage company, again, cash, you don't have to do it, but a mortgage company is going to require that homeowner's insurance. And the mortgage company is going to be named additionally insured on your homeowner's policy. Types of closings. We have generally 2 methods. We have a settlement or the round table closing. The documents are actually exchanged by the buyer and seller in person. Or we have the escrow closing, where the buyer and seller deliver all the documents to an escrow agent who holds documents in a trust until all the conditions are met. With an escrow closing, we may have the buyers come into an office one day, sign papers, have the sellers come to an office another day, sign papers, and we may be able to actually give them some papers. But what's magical about an escrow closing, nobody ever has to physically come anywhere. It can all be done via FedEx. We can transfer documents that way. And FedEx is the way we want to make sure that original documents go to the final place they got to go. A large amount of documents will be exchanged at the closing. Yeah, and you'll get hand cramps and everything signing all your documents. RESPA. This is the Real Estate Settlement Procedures Act. This guides how closings are done. Ensures the consumers are provided with information about the cost of their mortgage and closing costs. Consumerism at its best. The reason we have something called RESPA, the home is the biggest purchase most people are going to make. They need to understand what that means. Most people don't have a clue. They know they buy a house, they pay a mortgage payment, but they don't ever get the whole picture. One of the things RESPA is trying to do is give people the whole picture. So RESPA applies only to federal related mortgage residential. So if you're going to do Fannie, Freddie, they've all got to be following this RESPA procedure, because those are some federal programs. The residential property must be either a 1 to a 4 unit family structure or a manufactured home. It can be a mobile home. Different from a modular home, mobile home. Okay, so one of the things RESPA does is it gives you all of your costs to borrow money. So that's what I keep saying. You borrow for a $140,000 house, you pay it over 30 years, all of a sudden you've actually got a $400,000 home, because it's going to tell you all that interest that you're going to pay over the full time. And that's when you're going to feel like they turned you over and shook you out entirely at this closing, because it's the way of the world on you when you've got all of this money going on for years to come. It's a long commitment. It prohibits conduct from a person from giving or accepting kickbacks or unknown fees. Realtors used to get extra fees for getting the appraiser, for getting the house inspector, for getting the homeowner warranty, all those kind of things. Realtors got bonuses for doing all that stuff. Today, RESPA is saying, can't do that. Or if we're doing it, it's done in a fashion that everybody knows what's going on. RESPA would like to not have that happen. We don't like kickbacks. Penalties for the prohibited conduct, violations, anti-kickback, referral, unearned fees, provisions of RESPA can result in both criminal and civil penalty. So if they find that the realtors are guilty of this, they can come back, they can take your license away. There's criminal and civil penalties. And that is it for this chapter. Any questions? All right.
I got one.
Yeah, what's the question?
Is that house still out there in Fairfax where they have like a bazillion Christmas decorations in the front yard?
Oh no, Barbara and her husband quit decorating a couple years ago.
Did they really?
Yes.
I can take my kids there every
Yeah,
year.
we used to walk over there through the neighborhood all the time. And I knew Barbara and her husband. I knew Barbara years ago because I used to do a fitness class